What are the requirements to write a last will and testament? Hi, I'm attorney Paul Deloughery. Be sure to like and subscribe so that you can get more videos like this about how to protect yourself, your wealth, and your loved ones. So there are two categories of things that are required. Number one, you need a person to write the will, and the person has to satisfy certain things. And then the document itself has to satisfy certain criteria. So let's talk about the person first. First of all, the person needs to be 18 years old or older. Okay, 18 years old or older. So that's pretty easy to know one way or the other. Now, the person also has to have testamentary intent. So what does that mean? Testamentary Testamentary intent means the person signing the will needs to intend to give their property away in a specific way upon their death, okay? So it's not just a grocery list, for example. Now, there also has to be testamentary capacity. Oop. Testamentary capacity means that you have a sound mind, okay? You know what you're doing, at least when it comes to signing the will. And now there needs to be no undue influence. So that means that no one can be pressuring the person to sign the will, because that could be a defense that could actually invalidate the will. Also, the person has to sign the will. And so, sign the will. Or there's an exception to this. You can ask someone else to sign the will for you if, for example, you're laid up in bed and you can't move your hand. So that has to do with the person. Now let's talk about the document. There are 4 types of wills in Arizona that are valid. First is what's called non-self-proved. Non-self-proved. That means you have 2 witnesses, okay? So the person signing the will, and then there are 2 witnesses that, to keep this simple, that witness the will being signed, okay? There are some other ways to get around it, but basically, person signing the will, the testator, or female testatrix, and 2 witnesses. Then you have a self-proved will. So who cares? Oh, let me explain that. Self-proved means you have 2 witnesses plus a notary. Okay, notary, no notary, who cares? Here's why that matters. Well, if you have the will written in a certain way, and this is actually spelled out, there's a sample in the Arizona statute. If the will is written in a certain way, then after the person dies, everything can go very smoothly. Yes, there has to be a probate, but it can be informally, it's quick, easy, cheaper, relatively cheaper. However, if you don't have the notary and you only have 2 witnesses, it's still valid, but one of the witnesses needs to go to court and testify that, yes, I witnessed the will, and this is what happened, and the person satisfied all these criteria. They were 18, they have testamentary intent, and so on and so on. So now the next one, there's a handwritten will. You've probably seen this in movies, okay? Someone writes a note, and that gets held to be a will, and it can be valid. I actually was involved in a case years ago involving what was basically a grocery list. I know I joked about that a moment ago, but yeah, there actually was, this guy wrote out a grocery list to his wife, eggs, milk, cheese, you get the ranch when I die, dated and signed it. And so, yes, it was a grocery list, and it was also held, the court ruled that was a valid handwritten will. So there you go, okay? Now be careful, because I don't suggest that anyone do that, because it was a mess and there was a huge court battle and the relatives came in and the kids, the actual children from the prior relationship were bent out of shape because they didn't get anything, and anyway, it wasn't good. There was alcohol involved. Just note to self, don't be drinking alcohol right before you go trying to sign your will, okay? Usually doesn't end well. Next kind, in Arizona, we have what's called an electronic will. So, quick note about that. The idea is, you know, you've been on video conferences, and since COVID, this is a lot more normal now. Well, so the idea is that you get these people, either the two witnesses and the person writing the will, or you add a notary, and they're all on the video, and there's a certain procedure it's set forth in the statute. You have to do it very methodically, and then that can be a will. Now, my own personal take on that, I would be careful doing that, because it's basically an electronic file. And imagine when you pass away, here's this electronic file. Is someone going to be able to find it? I mean, where is it located? Is it like, you know, somewhere in the cloud, or is it on this laptop or that computer, or is it on your phone? Or anyway, it can be a mess. I'm kind of a proponent of traditional paper documents when it comes to this, because paper is easier to find and they can still be saved electronically, okay? So you can still have multiple copies, but you have the advantage of a paper copy that's a little bit more likely to be located by your loved ones when you're gone. This was a very quick summary of the requirements for a last will and testament. If you have any questions about a will or what happens after someone dies, give us a call. We're here to help.